Hello viewers, I am Dr. Wajda Rahman. Today we will discuss marriages among Hindus under the law relating to Hindu marriage. The main objectives of this module are to know about the legality of Hindu marriage, to know about the differences between early Hindu law and present Hindu law relating to marriage, to know about the rights and duties emerging in marriage among Hindus. Let's introduce the topic. Hindu marriage is seen as a sacred ceremony whereby a male and a female enter into a lifelong partnership primarily motivated by physical, social and spiritual necessities including dharma, reproduction and the sexual gratification. The sacramental core of marriage has three distinct characteristics. Number one, the marital connection between a husband and wife is characterized by its enduring nature, persisting even beyond death, ensuring their continued togetherness. Secondly, once established, this bond becomes indissoluble. Number third, this sacred and religious union between the bride and groom necessitates the observance of religious ceremonies and rites. The institution of Hindu marriage has important religious and cultural significance, being widely regarded as a crucial sacrament within the Hindu faith. In ancient times, the need for the bride's consent was absent. In traditional patriarchal societies, fathers were often granted the authority to make decisions about their sons and daughters without seeking input or approval from them. The responsibility of identifying a suitable male candidate lies exclusively with the father. In cases where an individual was deemed to be deficient in mental capacity or was a minor at the time of entering into a marriage. Such unions were not regarded as void marriages. In contemporary society, the presence of consent and mental capacity have significant importance within the context of Hindu marriage. Without these elements, the marriage in question would be rendered null and invalid. According to Section 12 of the Hindu Marriage Act 1955, in cases where consent is not acquired, the marriage is said to be invalid. Now discuss with the emerging concept of marriage-like relationship. The contemporary institution of marriage is characterized by contractual aspects. Therefore, it embraces the concept of equality and liberty. The adoption of this concept may be attributed to the influence of Western ideologies. For the agreement to be valid, both parties must engage in it freely. Therefore, it may be argued that Hindu marriage neither possesses the characteristics of a contractual agreement, nor does it have the quality of a sacrament. However, it may be argued that it has characteristics of both. The clarification of emerging and diverse marital partnerships is a subject of inquiry, since no definitive definition can be found within existing texts or statutes. These relationships are often referred to as non-marital relationships, de facto relationship, quasi-marital relationship, cohabitation, and pair relationships, among other terms. The terminology for these partnerships varies throughout various regions of the globe. For instance, in India, they are referred to as relationship in the nature of marriage, while in New Zealand, they are known as de facto relationship. In Canada, it is known as common law marriage. In Queensland and Australia, they are often referred to as couple relationship. Yet in Hungary, the term cohabitation is used. In France, they are commonly referred to as civil unions. These partnerships pertain to individuals of opposite genders who are not married but possesses the capacity to legally enter into marriage, meet the age requirements for marriage, and are recognized by society as being in a marital union. In India, the legal system acknowledges these partnerships as being akin to marriage and affords them protection under the Protection of Women from Domestic Violence Act of 2005, subject to additional conditions as determined by the court on a case-by-case basis. Now let's discuss the conditions for the validity of a Hindu marriage. According to Section 5 of the Hindu Marriage Act 1955, a legitimate marriage may be conducted between two individuals who identify as Hindus, provided that the following criteria are fulfilled. Number 1, neither party had a living spouse at the time of the intended marriage. As per the provisions outlined in the Hindu Marriage Act, the act of simultaneously maintaining two living wives or husbands is deemed impermissible, constituting the offence of bigamy. The Supreme Court of India held in Yamuna by Anantrao Adhar versus Anantrao Thairaram Adhar, that is 1988 Supreme Court case, that a marriage becomes null and void when it is in violation of the condition specified under Section 5, Subclause 1 of Hindu Marriage Act. The act of bigamy, subject to legal consequences as stipulated in section 494 of the Indian Penal Code for bigamy. Bigamy refers to the act of having two living spouses at the same time, a practice that is deemed unlawful according to Hindu law. An individual must complete the divorce proceedings of their first marriage before entering into a subsequent marital union. The individual who enters into a second marriage while still having a living spouse would be subject to the provisions outlined in section 494 and 495 of the Indian Penal Code 1860. Next, the individual must not exhibit any signs of insanity or mental condition at the time of entering into the marital union. In S. Lakshmi Narayan versus Shanti, that is 2001 Supreme Court case, the Supreme Court of India observed that to brand a wife as unfit for marriage and procreation of children, it needs to be established that the ailment suffered by her is of such a kind or such an extent that it is impossible for her to lead a married life. Next, in a Hindu marriage, the groom is required to reach the age of 21, while the bride must reach the age of 18. In accordance with the provisions outlined in this act, it is essential that an individual reach the prescribed age at the time of entering into marriage. Child marriage, as stipulated by the Hindu Marriage Act of 1955, does not fall under the category of being either invalid or voidable. The High Court of Delhi, in the case of Neetu Singh versus the State and Others, 1999 case, rendered a decision affirming that the act of marrying children is not considered invalid or voidable, but rather constitutes an offence subject to legal penalties. According to the Prohibition of Child Marriage Act of 2006, the minimum age for marriage is set at 21 years for males and 18 years for females. A declaration of nullity may be sought by a female individual who has engaged in a marriage during her childhood, provided that this marriage occurred before her attainment of the age of 18. Next, individuals who do not belong to the Sapinda relationship or fall within the prohibited degree of relationship are exempted from such restrictions if their customs or traditions permit otherwise. In Srimati Shakuntala Devi versus Amarnath, that is 1982, Punjab and Haryana High Court, held that the validity of section 5 subclause 4 is subject to customs and usage accepted in a particular Hindu community. Next, discuss about the concept of void and voidable marriages. In the event of any barriers or blockages, the parties involved are precluded from entering into a matrimonial ties. When an individual enters into matrimony and encounters any barriers throughout the marriage proceedings, it might be concluded that the marriage is not legally recognized or lawful. These impediments gave rise to the classification of marriage, which is void marriages, voidable marriages. Let's discuss the void marriages. Absolute obstacles refer to certain circumstances that render a person ineligible for a legally recognized marriage, resulting in the marriage being deemed unlawful or illegal from its inception. Within the context of obstacles, these exist a relative impediment that prohibits the union of marriage with a certain individual, resulting in a void marriage. Under Section 11 of Hindu Marriage Act, the conditions of void marriages are referred to. A marriage is considered void under the Hindu Marriage Act if it does not satisfy the following conditions of Section 5 of Hindu Marriage Act 1955. Number 1, bigamy. Bigamy is the act of entering into a marriage with a person while still being legally married to another one. If any of the parties involved in a marriage had a surviving spouse at the time of the union, it would be deemed null and invalid. For example, there are 3 parties, A, B and C. Party A is first married to spouse B, but afterward enters into a second marriage with party C. This situation is classified as bigamy, which is legally void. Next, the degree of prohibition. If the parties are involved in a relationship that is unlawful unless there are conventions or traditional norms that permit it. In this scenario, person A represents the husband while entity B represents his wife. They engage in a marriage that is legally forbidden. This union may also be referred to as a null and void marriage. Next, the sapindas. A matrimonial union will be considered unlawful if individuals who are sapindas, or in other words, individuals who have a familial relationship or belong to the same family, are involved. In this scenario, person A represents the husband while entity B represents his wife. It is important to note that entity B has a blood link or a close familial connection with entity A, which may be referred to as sapinda. Therefore, this procedure will be regarded as null and void. Next, religious conversion. The phenomenon of religious conversion is a topic of significant academic interest. In the case of Sarla Mudgal versus Union of India 1995 Supreme Court case, the Supreme Court of India ruled that the act of a Hindu husband entering into a second marriage after converting to Islam is considered a void marriage under Section 494 IPC, which pertains to the consequences of a void marriage. Now, let's discuss the voidable marriage. A marriage that may be declared invalid, as outlined in Section 12 of the Hindu Marriage Act, on the grounds of either party is referred to as a voidable marriage. The validity of the marriage will remain intact until a petition is filed to challenge its validity. The marriage is to be declared null and unlawful by a legally authorized court under the provision outlined in the Hindu Marriage Act of 1955. The individual involved in such marriage would deliberate on whether they choose to continue with the union or declare it null and void. The grounds upon which a marriage may be considered voidable include situation. Number 1, where one person lacks the capacity to provide consent due to mental unsoundness. For example, A represents the husband and B represents his wife. The individual denoted as B provided permission for the marriage while experiencing a state of mental incapacity. After a certain period of time, individual B successfully recovers from their ailment and asserts that their consent during the marriage was invalid. They argue that the marriage should be considered voidable due to their unsound mental state at the time of providing consent. Therefore, this situation pertains to the concept of a voidable marriage. The individual in question is afflicted with a mental illness that renders them unsuitable for engaging in the process of procreation. For example, A represents the male spouse and B represents the female spouse. If individual B is experiencing a mental condition that renders them incapable of engaging in the process of procreation, this circumstance may serve as a basis for a marriage that is subject to being declared voidable. Next, if the party has been experiencing recurrent instances of mental instability. For example, A represents the husband and B represents his spouse. If any party has recurring episodes of mental illness, the circumstance may also serve as a basis for a marriage to be deemed voidable. Next, the act of obtaining marital consent from one of the individuals, another one involved in coercion or deception, makes the marriage voidable. For example, A represents the husband and B represents his wife. If either partner has provided permission for the marriage under duresses or via deceit, the marriage in question may be deemed voidable. In a Hindu marriage, when one or both of the parties are under the age of a minority, the marriage becomes voidable at the option of the other. It is illustrated that A represents the husband and B represents his wife. If individual B is below the age of 18 years, the marriage in question may be deemed voidable. Similarly, if individual A is below the age of 21, the marriage may also be subject to voidability. At the time of the marriage, the respondent is carrying a child conceived with a person other than the groom. For example, A represents the male spouse and B represents the female spouse. At the time of the marriage, individual B becomes pregnant by a third party during the period of the marriage. Subsequently, the marriage would be deemed voidable at the option of the husband. Next, discuss the necessary conditions to be fulfilled by a petition under section 12 for the nullity of a voidable marriage. That are: number 1, a petition should be submitted to the court within 1 year after the discovery of fraud or the use of force in relation to a marriage. Secondly, the petitioner was unaware of the accusation upon which the petition was filed at the time of the solemnization of marriage. The submission of a petition regarding an accusation must occur within a 1-year time frame from the point at which the relevant facts are known. Next, there is no establishment of a sexual connection subsequent to the acquisition of information about purported facts. Next, discuss children of void and voidable marriages. The determination of the legitimacy of children born from marriages that are considered void or voidable is outlined in section 16 of the Hindu Marriage Act of 1955. In the context of a void marriage, offspring born outside of the marriage are to be regarded as legitimate. Within the context of a voidable marriage, any child born from a marital union that is later declared null and void by a court is considered legitimate, despite the circumstances surrounding a marriage that falls under Section 11, that is void marriage, or Section 12, that is null and void marriage. The child born from such a union is deemed legitimate. In Bharat Matha and another versus R. Vijaya Ranganathan and others, that is 2010 Supreme Court case, it was held that children born from void or voidable marriages were entitled to inherit only their father's self-acquired property, excluding ancestral co-personal property. However, in the case of Ravani Siddappa versus Mallikarjun 2011 Supreme Court case, the Supreme Court said that children born from marriages that are considered invalid or may be annulled have the right to inherit both self-acquired and ancestral property of the parents. Let's conclude the topic. Hindu marriage is considered a sacred ritual that is performed with the recitation of Vedic mantras in the presence of a deity with the purpose of satisfying religious and societal obligations with the ultimate goal of attaining moksha. According to scholarly perspectives, Hindu marriage is believed to possess a scientific framework that serves to establish and maintain societal order. This is achieved via the safeguarding of children as well as the elderly parents and by encompassing all aspects of human existence. Consequently, the overall objective is to contribute to the well-being, prosperity, and triumph of society. Therefore, the significance of women persisted throughout several ancient epochs. Over time, the notion of marriage has undergone a transformation from being seen as a sacrament to being understood as a contractual agreement, mostly influenced by societal change. The institution of marriage has experienced additional influences from evolving and diverse relationship dynamics, resulting in consequences for the quality and stability of marriages. This has led to a decline in the overall state of marriage, particularly with less developed marital relationship. The influence on decisions regarding marriage and the estrangement of marriage individuals from their families. The legislature, in response to the demands of the era, passed a series of laws from 1829 to 2006 to address the evolving requirements of society. The court has significantly contributed to the preservation of the institution of marriage through its extensive analysis and interpretation of several instances. That's all for today's lecture. I hope you have enjoyed the lecture. Thank you very much.